Have you ever wondered if the government could wake up one morning, reach into your bank account, and take your money without ever stepping inside a courtroom? It sounds like something that shouldn't be possible, yet in 2026, there is one agency that has this extraordinary authority under federal law. But before that thought sends you into panic, here's the part that most people never hear. The IRS cannot simply empty your account whenever it wants. There are legal protections, mandatory waiting periods, and rights that can completely change what happens next if you know how to use them. By the end of this video, you'll understand exactly when the IRS can levy your bank account, what they must do before taking a single dollar, and why thousands of people lose money simply because they never realized they had options. One of the biggest misunderstandings people have is believing that every creditor follows the same rules. If you stop paying a credit card, a personal loan, or even certain medical bills, the company generally has to sue you in court before it can collect directly from your bank account. A judge has to review the case, and the creditor must obtain a judgment before moving forward with collection efforts. The IRS operates differently. Congress has given the Internal Revenue Service special collection powers that most creditors simply don't have. When someone owes federal taxes and doesn't resolve the debt after repeated notices, the IRS can use a legal tool known as a levy. A bank levy allows the agency to instruct your financial institution to freeze money in your account and eventually send those funds to the government to satisfy the unpaid tax debt. That sounds frightening, and for many people it is. But the important thing to remember is that this process is never supposed to happen without warning. The heirs cannot simply decide today to freeze your account tomorrow without following specific legal procedures. Understanding those procedures is what gives you the greatest chance of protecting yourself. Before the heirs can issue a bank levy, it must first notify you about the unpaid taxes. In many cases, taxpayers receive multiple letters over time explaining the balance owed and requesting payment. If those notices are ignored and no agreement is reached, the IRS eventually sends one of the most important documents you'll ever receive if you owe back taxes. This notice is called the Final Notice of Intent to Levy, and it also explains your right to request a hearing. That letter is more than another piece of mail. It represents a critical turning point in the collection process. From the date that final notice is issued, the IRS generally must wait at least 30 days before moving forward with a levy. Those 30 days are not just a courtesy. They exist because federal law gives taxpayers the opportunity to challenge the proposed collection or work out another solution before money is taken. Unfortunately, many people never take advantage of that opportunity. Some are overwhelmed by fear. Others assume there's nothing they can do. Many simply avoid opening IRS mail because they expect bad news. Ironically, ignoring the notice is often what creates the very outcome they were hoping to avoid. During that 30-day period, you have the right to request what's known as a collection due process hearing. When that request is submitted on time, the IRS generally must pause levy action until the hearing has been completed and the matter has been reviewed. Think about how powerful that is. One written request submitted before the deadline can temporarily stop the collection process and give you time to present your situation. Yet countless taxpayers never exercise this right simply because they don't know it exists. Even if the IRS eventually sends a levy to your bank, there is another safeguard built into the process that many people never hear about. Your bank doesn't immediately transfer the frozen money to the government. Instead, once the levy arrives, the bank generally freezes the funds that were in your account at that moment and holds them for 21 days before sending them to the heirs. That waiting period serves an important purpose. It gives you one last opportunity to resolve the issue. There's another protection that is especially important for retirees and people living on limited income. If paying your tax debt would prevent you from meeting basic living expenses like housing, food, utilities, or medical care, you may qualify for what's called currently not collectible status. When the IRS determines that collecting the debt would create severe financial hardship, active collection efforts can be suspended. That means no bank levy, no wage garnishment, and no aggressive collection actions while your financial situation remains unchanged. Many seniors qualify for this protection, but never request it because they assume the government won't listen. In reality, financial hardship is something the IRS is required to consider. Another widespread misconception involves Social Security benefits. Many people believe the IRS can simply take every dollar of a retiree's monthly check until the debt is paid. That isn't how the law generally works. For many federal tax collections involving Social Security retirement and survivor benefits, the IRS is limited to taking only a portion of the monthly payment through its continuous levy program. Instead of losing everything, most recipients continue receiving the majority of their monthly benefits. That distinction matters because it means people are not automatically left without income simply because they owe taxes. The protections become even stronger for certain other federal benefits. Supplemental Security Income, commonly known as SSI, is designed for individuals with very limited financial resources. Because of its purpose, these payments receive significantly stronger legal protection against IRS collection. Likewise, many Veterans Affairs disability benefits receive important protections under federal law, giving veterans additional safeguards against losing essential income. Understanding which benefits are protected and which collection methods apply can make an enormous difference during financial hardship. Consider two taxpayers with nearly identical situations. Both owe the same amount in unpaid federal taxes. Both received the same final notice from the IRS. Both are worried about what might happen. The first taxpayer opens the letter immediately. Instead of pretending the problem doesn't exist, they call the IRS, explain their circumstances, and ask about available options. After reviewing their finances, they establish an affordable payment arrangement or qualify for temporary hardship relief. Months later, their bank account remains untouched because they addressed the issue before enforcement became necessary. The second taxpayer reacts differently. They see the government envelope, feel anxious, and place it on a table without opening it. Days become weeks. Weeks become a month. Eventually, the legal deadlines expire. Only after discovering that their bank account has been frozen do they finally begin making phone calls. Both people started with the same debt. The biggest difference wasn't income. It wasn't luck. It was simply whether they acted while they still had time. This is why ignoring IRS correspondence is one of the costliest mistakes a taxpayer can make. Every protection we've discussed depends on responding before important deadlines pass. The right to request a hearing, the opportunity to negotiate payment, the ability to demonstrate hardship, the possibility of stopping a levy before money leaves your account. None of those protections help if the letters remain unopened in a drawer. If you ever receive correspondence from the IRS, resist the urge to avoid it. Open it. Read it carefully. Pay close attention to every deadline listed. Even if the situation feels overwhelming, understanding what the notice says is always better than allowing the clock to run out. If the notice mentions a final notice of intent to levy, treat it seriously. That document signals that time is limited, but it also means important legal rights are still available if you act quickly. Remember that you don't have to handle everything alone. The IRS has representatives who can discuss payment arrangements and collection alternatives. Qualified tax professionals, enrolled agents, certified public accountants, and tax attorneys can also provide guidance depending on the complexity of your situation. In many communities, low-income taxpayer clinics offer assistance to eligible individuals who cannot afford professional representation. Seeking help early is almost always easier than trying to reverse a levy after it has already occurred. The biggest takeaway is surprisingly reassuring. Yes, the IRS has powers that ordinary creditors don't possess. It can levy bank accounts without first filing a lawsuit in court, but those powers are surrounded by legal requirements that are designed to give taxpayers notice, time to respond. Knowledge reminds you that you do. If you or someone you know worries about unpaid taxes, don't wait until a bank account is frozen to learn how the process works. Understanding the rules today could help protect your finances tomorrow, and sometimes the simple act of opening one envelope and responding before the deadline is the difference between solving a problem and making it much harder to fix.